Afternoon, sir.
Good afternoon, Madam President. Good to see you up there. I'm interested that you said, let the games begin, because this particular bill, I think this is our fourth round. So it's almost as if we're in a boxing match over this particular policy. And I'm happy to have won the previous rounds, that this bill did not become law. And I'm hopeful that once again, we are able in the minority to prevent this. This particular policy is one that has come to us in consecutive years, despite being somewhat controversial. Even reports that the governor has the great potential of vetoing this particular policy. I noticed also that the good chairman who brought out the bill said, quote unquote, that folks were unemployed. This will help people who are unemployed as a result of a labor dispute. And I guess that's the main argument of this bill, which is whether or not folks are actually unemployed if they choose to voluntarily go on strike and leave employment. And that's what we're going to debate here today. In previous years, I focused a lot of my remarks on the subject of fairness, because really this is kind of what this is about. There's an argument coming from the majority that this would create fairness. This would create an opportunity for employees who are on strike to be able to still earn a level of income so they can prolong and maintain their ability to collectively bargain and argue over the terms. And me on the minority side, I would say that that's facetious on its face, that the whole point of a labor dispute and the resulting strike or a lockout in the case of an employer is all about the fact that you have to put up with some element of pain in the negotiation to show how significant the problem is that you're trying to address. And this particular bill effectively makes it easier for one side of that equation to go on strike. If we had the opposite situation where we were going to ask the taxpayers of Connecticut or the employees, in fact, to pay for a business to lock them out, it would be absurd on its face, and people would say so. So to make the argument that somehow we should have the actual employer, via their unemployment insurance premiums that they pay into our state fund, which is subsidized and backed by the federal unemployment trust fund, to have them make the payments to finance the ability for the employees to go on strike, to negotiate and bargain against them, is equally absurd. And I think that that is the whole argument in a nutshell. There isn't a whole lot more to say beyond that, although we're going to have a little bit of a debate about some of the merits of these arguments and really what the bill says and what it gets to. For me, fairness is defined the way children define fairness, which is that, and I think I point that out because I think kids understand this even better than grown adults sometimes, which is that if you do something and you work hard for it and you are in the right, then you should get the reward. But if you are slacking off, if you're not doing your job, then you deserve the consequences. We live in a country of freedom. That is the most paramount virtue that we possess as Americans. And in order to maintain freedom, it has to be balanced with consequences. And the point I'm trying to make is that in life, there are consequences. When you work hard and you put effort in, generally speaking, you get a positive result. If you don't work hard, if you slack off, you don't bother to put effort into your education or to your occupation, you're not going to go as far in life. That's just a fact of life. That is what true fairness is. And I'm concerned because this policy is a symptom of the political left and their desire to upend the very notion of fairness, to turn it into something else, to make it seem that fairness is ultimately about outcomes and not opportunity. For me, fairness is to make sure that people all have the same opportunity to achieve, but the result that they get, the consequence that they get, is based on their own effort. This policy seems more focused on the progressive notion that we should be less concerned with opportunity and more concerned with outcomes, and that people deserve to end up in the same place regardless of their own individual input. And to me, that's disturbing, because that is in direct contradiction to, I think, what defines us as a nation, and I think it's also in direct contradiction to what has provided the quality of life that we have here in the United States of America, which is based on free market capitalism, people trying to outdo one another, yes, but also engaging in free and uncoerced commerce. People choosing to make purchases or offer services for payment, all with the desire to benefit their own interests. And somehow, a very effective messaging on behalf of people that disagree with the idea of free market capitalism, to paint that as a negative, that the idea that someone would act in their own interest is somehow evil or greedy. No, that is the driving force behind what makes prosperity. Prosperity comes from the direct impact of people acting in their own self-interest. And acting in your own self-interest is not the same thing as acting at the expense of another person. And I think that that's where people fall prey to this phony and false argument. You know, if I decide I want to make a purchase, I've got to make a choice whether or not I'm willing to take the money out of my pocket and hand it over to the person selling something, and they've got to make the same choice of whether it's worth it to sell that product for that price. And that goes for services as well as goods. But in capitalism, the parties only actually come to an agreement if they decide individually on their own of their own free will. All other forms of government and organization and commerce require some third party, some outside force. And in the case that I'm referring to here, it's the government that is applying force to one side, or in some cases both sides, of a negotiation, either for goods or services. I think it's a dangerous path that we're headed on, and I am taking the time to kind of lay the groundwork for the basic struggle in a bill like this, which is, do we preserve our American system of freedom and consequences, our American system of capitalism, or do we go down the road of progressivism or a collectivism that ultimately throughout history has led to disaster and death? And for me, one other important part of this argument is about the role of this body. You know, what is the role of the state Senate? What is the role of the Connecticut legislature in a labor dispute? Frankly, I don't know that we have one. I believe that government has a role to play, and that role should be very limited in the sense that I believe that we have courts, we have a justice system that is designed to protect the parties and their contractual obligations to one another. That is the main role of government. In my view, you should have employers and employees negotiate the terms of employment on their own without any outside force from anyone, whether it be government or any other party. And at the end of the day, the government's role is simply to step in if one party does not honor their side of the agreement. You have a recourse to go and say to the court system, this person was supposed to pay me X, or they were supposed to provide a service and they have failed to do so. Mr. Government, please help me solve the problem. So I do see a role for government, but it should be limited in that way, and not as it has been used, even as recently as last week, where we passed another labor bill that goes ahead and uses the force of law, uses the force of the state government to require one party of a labor transaction to maintain a certain policy or offer a certain benefit to the other side of a transaction. And for me, that's an improper use of government. This is an even more improper use in this particular case, frankly, because what we're talking about here is a situation that is a collective bargaining agreement in most cases, where you have a union organization, its employees making a decision to negotiate the terms with their employer, and if they can't come to an agreement on their own, they have a mechanism, which is a strike, to be able to use the most powerful force that they have to effectively shut down the employer's business, to make an issue about their current working conditions or wages or whatever their concern is. That is a very powerful move. And it requires that they take risk of their own economic situation in order to go ahead and pursue that. For the state government to decide that it's in a position to come along and to provide a benefit to them in the meantime, to strengthen their position, is putting a weight on one side of that otherwise fair negotiation. And that's the main objection that I have to the bill today. The financial mechanism that is contemplated in the legislation before us is the Unemployment Compensation Trust Fund, which is a fund that is set up specifically to aid employees who end up out of work through no fault of their own. That is the whole point of the Unemployment Compensation Trust Fund. In this particular bill, what's happening is we are going to use the Unemployment Compensation Trust Fund to aid employees who are out of work of their own choice. Clearly, that will have an impact on the solvency of that trust fund. And I have a little bit of research that tells me that in recent years, we are just barely maintaining our state unemployment trust fund. It is just barely in the positive. In fact, most months, including February, March, April, and May of 2025, we are very much in the negative. And what happens is that when we are in the negative, the state is required to borrow money from the federal government to supplement our trust fund. And if we go 2 Januaries in a row where we are in the negative, then what happens is that we apply a surcharge on employers to charge them more in their unemployment insurance premium. And I fear that that is an inevitability if this policy proceeds, because we are in a situation where we are borderline, in fact, negative each month already. I have some questions I want to ask the proponent of the bill, if I could, Madam President.
Please proceed, sir.
The first question I have really is just to clarify a few parts of the language of the bill. And I understand it's only a couple of sentences really that are changing in our current statute. And some of this might sound familiar to the good chairman, because we did talk about this the last time we had this debate. But this says effectively that someone will be eligible for unemployment compensation based on a labor dispute. Is there a definition of a labor dispute through you, Madam President?
Thank you. Senator Kushner.
Thank you, Madam President. I believe there is a common understanding of labor dispute. I don't believe it appears in this amendment.
Thank you. Senator Sampson.
Well, thank you very much, Madam President. A common understanding. I mean, normally when we write laws, we put into the statute definitions of important terms. And frankly, I'm disappointed because I asked this exact question the last time that we debated this bill, which I believe was on this Senate floor in 2022, was the last time we actually had a significant debate over this particular language. And I asked that question: what is a labor dispute? Is that defined as just a disagreement about payment? Or if I think what I asked the last time is whether or not if the employer came and said, you know, listen, I'm going to change the colors of your uniforms today to their employees, would that qualify as a labor dispute? Through you, Madam President.
Thank you. Senator Kushner.
Thank you, Madam President. I don't want to read from statute, but I do want to direct the good senator to Title 31, Labor, Chapter 562, Labor Disputes, Section 31-112, where there is a definition of labor disputes, and you can find it there and read it for yourself, or if you care for me to, I could read it into the record. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I don't think we need to hear the entire passage, but maybe a summary of what a labor dispute says according to that, through you.
Thank you, Senator Kushner.
Thank you, Madam President. I believe the relevant words define a labor dispute, including any controversy concerning terms or conditions of employment or concerning the association or representation of persons in negotiating, fixing, maintaining, changing, or seeking to arrange terms of condition of employment or concerning employment relations, or any controversy arising out of the respective interests of employer and employee, regardless of whether or not the disputants stand in the proximate relation of employer and employee.
Thank you, Senator Sampson.
And thank you very much, Madam President. I appreciate that clarification, although it's not much of a clarification in my view. It's pretty broad, and I'm not saying that's necessarily a negative, but I was hoping that there'd be something a little more concrete in our statute or a definition in the bill to really define what cases this would apply to in a succinct manner, because in my view, this can apply in very broad terms. One aspect of this that, we touched on the last time we had this debate but was never really resolved is that normally a strike occurs when you're talking about an actual collective bargaining negotiation breaking down. And I don't believe that's required in this particular bill. And I'd like to confirm that through you, Madam President. Is it that a strike can only occur, or a unemployment, this bill would apply, let me start over. An unemployment benefit would apply in this bill regardless of a collective bargaining negotiation breaking down. It simply requires a labor dispute. Am I correct about that, through you?
Thank you, Senator Kushner.
Thank you, Madam President. Through you, you are correct.
Senator Sampson.
And thank you very much, Madam President. This is why I wanted to spend a little time on this portion of the bill, because I think it gets a little sticky here. Generally speaking, people go on strike after there's an attempt at a negotiation. Is there a requirement that there is an attempt at a negotiation in order for this bill to kick in, through you?
Senator Kushner.
Thank you, Madam President. No, there's not.
Senator Sampson.
Thank you very much, Madam President. So these are surprising things that I don't think other people have contemplated about this particular proposal. I think most people are just assuming that this is going to be based on your typical notion of a union going on strike after a failed negotiation with an employer, and then we're going to provide this unemployment compensation after 2 weeks of a continuous strike. But this really is far more expansive than that. It doesn't require unions involved. It doesn't require that there's collective bargaining involved. It doesn't require that there's actually a breakdown in a negotiation involved. And I'm going to bring up one more point that I think is actually even the most shocking of all of that, which is that I believe this applies to individuals and not even multiple employees. Through you, Madam President, can I get a clarification from the good chairman whether or not this bill applies to individuals, or there is a minimum number of folks that have to be part of the labor dispute, through you?
Thank you, Senator Kushner.
Thank you, Madam President. According to our statutes, it would be involve one or more employees.
Thank you, Senator Sampson.
Thank you very much, Madam President. Yeah, so one or more employees. So we just figured this out. This means that any person can walk off the job anywhere and they can get unemployment compensation. That's what this bill allows. Am I correct about that, through you, Madam President? And if so, if not, then why?
Thank you, Senator Kushner.
Thank you, Madam President. I do believe that the Department of Labor would have the ability in its unemployment unit to determine whether or not there was a true labor dispute at issue here. Through you, Madam President.
Thank you, Senator Sampson.
Through you, Madam President, can I just ask for clarification of where it says that the Department of Labor will make a determination whether or not this labor dispute is legitimate for the purposes of applying for this benefit under this proposed bill? Through you.
Thank you, Senator Kushner.
Thank you, Madam President. This bill provides that employees involved in a labor dispute would be eligible to collect unemployment. There are regulations, and there's a whole division in the Department of Labor for unemployment claims, and I believe this would follow under the same scrutiny that you would have in any other disputed claim. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate that response, although it doesn't really give me any clarity about what's happening here. I mean, I think the words on the paper are the most clear. We already started this conversation by describing a labor dispute. I asked the good chairman to explain to me what a labor dispute is because it's not defined in the bill, and I was given an extremely broad definition, which is basically if the employer and employee disagree about anything. That's it. It's the definition. And then we clarified that they don't even have to attempt to negotiate it. As long as the dispute exists, there's no requirement that either the employer or the employee attempt to negotiate the dispute. We clarified that. And then we clarified that it can be one or more employees. So it could be a single person who's unhappy at their job. And they can simply say, I don't like my working conditions. They don't have to go and try and negotiate those working conditions with the employer. And in a sense, ultimately, this gives any employee in the state of Connecticut the power to simply walk off their job and collect unemployment compensation. And I will ask once again whether or not that is what the bill says. And if not, I would like a substantive answer, not this Department of Labor has the ability to reconcile disputes. We give them the power to reconcile the dispute by creating the law and the statute that they must follow. So what I'm looking for is something in the statute that says that what I'm saying is not true. Because I'm confident after reading this, going on 5 years now, of going over this same kind of concept repeatedly, I know what it says. Through you.
Thank you, Senator Kushner.
Thank you, Madam President. Through you, I believe I've answered the question appropriately. There is, within the Department of Labor, a unit that is designated where there's any claim that's in dispute, that it would automatically trigger adjudication if there's any reason other than lack of work given in an application for unemployment.
Thank you, Senator Sampson.
Thank you very much, Madam President. So the same answer, which is the Department of Labor would have to adjudicate a dispute. And in order for there to be a dispute, I presume that one of the parties, in this particular scenario, the employer, would have to dispute the claim by the employee. And I'm going to ask this same question a third way, which is what in the statute would give the employer grounds to disagree, since the law says all that has to happen is there's a labor dispute. Through you.
Thank you, Senator Kushner.
Thank you, Madam President. It is not uncommon for employers to dispute a claim for unemployment benefits, and just as in any other process, if an employer did challenge that claim of an employee that there was a labor dispute, there would be a hearing process in the Department of Labor and a determination would be made. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Well, I appreciate that response, but I would ask the good chairman, under what circumstances do employers normally dispute an unemployment compensation claim presented by an employee? Through you.
Thank you, Senator Kushner.
Thank you, Madam President. My office often deals with claimants, with individuals who've applied for unemployment benefits and have been denied. There are many reasons that could happen. Most frequently, I find it's because the employee was not aware that other part-time employment or temporary employment that they had counted against their ability to collect. But it could be for any reason. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate that answer. But wouldn't the mere fact that the employee is attempting to collect unemployment benefits indicate that they have a dispute with their employer? Isn't that pretty obvious? I think it's pretty clear. The standard, the bar for a labor dispute is simply anything. And if there is no requirement that either party even has to engage in an effort to negotiate the disagreement before the benefit is allowed, I don't see how the Department of Labor could ever deny any claim for unemployment. I'm not seeing it, frankly. I'm just not. It seems pretty cut and dry on the paper in front of us. Normally, when there's a dispute over unemployment at the Department of Labor today, it's over whether or not the person qualifies for unemployment. And I'll just remind everybody that the Unemployment Compensation Trust Fund is set up for a specific purpose. It is to aid people who are employed through no fault of their own. There's 3 requirements, actually. You have to be unemployed through no fault of your own. You have to be able to work. And 3, you have to be looking for work. And generally speaking, when there is a dispute currently at the Department of Labor, the employer is saying that the person does not qualify based on one of those 3 things. This bill takes those 3 things and throws them right out the window. You no longer need these 3 things anymore. All you need is to be a single person, no union, no collective bargaining, no attempt to negotiate, and you're eligible. All you need is to say, I have a labor dispute. And we already ascertained that the state statute is the broadest of all terms. There's simply a disagreement about the employer-employee relationship. And I guess it could be as simple as the employee doesn't feel like they need to go to work, and the employer feels that they do. According to the definition that we heard, that qualifies as a labor dispute. How are we going to, based on this, prevent abuse of this unemployment compensation fund? Through you, Madam President.
Thank you, Senator Kushner.
Thank you, Madam President. And I believe that the Department of Labor will have every opportunity to create guidelines that they would address for a labor dispute. Currently, they obviously have already, in law, we have the opportunity for workers who are locked out in a labor dispute to collect unemployment. So I believe the department is probably well aware of it. I also want to point out that other states that I mentioned previously, New York State and New Jersey, have had this statute in place for a number of years. In New York, it dates back to the 1970s. And I'm confident that given the experience of New York State and New Jersey, we have not seen great amounts of fraud or individuals who just decide they don't want to work, claiming unemployment under their statutes. I feel confident that the state of Connecticut will have resources to pull from to determine and make a determination in the unemployment insurance unit of DOL when it is a true labor dispute. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the response. I would ask, just to keep that conversation going, is it the position of the good chairman that these other states that have enacted similar legislation to provide unemployment compensation to workers on strike, that they have the same exact bill language that is before us? Through you.
Thank you, Senator Kushner.
Same language, but the process and the intention of this legislation is the same, to cover labor disputes that result from workers going out on strike. Thank you, Madam President. Through you.
Thank you, Senator Sampson.
Thank you very much, Madam President. And I appreciate that answer, but I think it kind of proves my point, which is that the process and intent of the legislation is a lot less important than the words on the paper. And presumably in these other states, they've actually considered the concerns that I've raised here today that obviously have not been addressed by members of the majority that put together this policy. Instead of crafting a policy that is isolated only to the failure of a collective bargaining negotiation that involves multiple employees in a union strike, they have drafted a bill that essentially allows any single individual to walk off a job and collect unemployment compensation for any reason effectively. Because the only requirement is a labor dispute, and the term labor dispute applies to anything whatsoever. It's actually shocking how broadly this is written. And I will tell you that the concerns I raised from the outset about the solvency of our unemployment trust fund are directly related to this conversation. Because the more you open this up, the more the unemployment trust fund is going to be used. And we got into this conversation with my question about how do we prevent abuse. The Governor Newsom, someone not known to be a strong conservative, opposing the expansion of progressive union ideas, he vetoed legislation that I guarantee you was more narrowly tailored than this. And he cited the exposure of the solvency of their California unemployment fund as the reason. So I'll ask again, since this is so broadly written, and since we know that even a progressive governor like Governor Newsom vetoed this similar legislation that was most certainly more narrowly tailored than this because of concerns, how are we going to prevent abuse in Connecticut? Through you.
Thank you, Senator Kushner.
Thank you, Madam President. We have been fortunate in our state that there have been very few strikes that have lasted longer than 14 days. And to be clear, that initial requirement of 14 days is written into this proposed bill. There have been very infrequent cases of this. Most of the strikes that have occurred in Connecticut are well established and well known. And I don't believe it will be difficult for the Department of Labor to adjudicate a false claim. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the confidence of the good chairman, but I completely and utterly disagree, and we're talking about our opinions here, and they have no relevance, effectively. The only thing that matters is what the statute ultimately says. And I would also correct the good chairman to say that this bill is not about striking workers. It is about a labor dispute. Any labor dispute between any single employee and their employer. Certainly it would also come into play in an actual union strike, but the bill is much more broadly written than that. And since we're talking about union strikes, I want to just hear a justification for this legislation. Because effectively what we're doing is we're passing a policy that would in fact unlevel the playing field by putting an advantage on the side of the employee or employees to force the employer to come to the table. And not only are we doing that, we're actually going to ask the employer to pay for it, to fund it. So how do you justify forcing employers to pay higher unemployment insurance premiums to fund strikes against their own business or other businesses? Through you.
Senator.
Thank you, Madam President. And I do want to acknowledge that there is a statutory reference in Connecticut, an additional reference, which is Section 31-236-40, that defines, again, a labor dispute. And it says in that current definition, individual is ineligible for benefits during any week that they find partial employment. In that, there is a definition of class or organization of workers, members of which immediately before the commencement of a labor dispute were employed at the premises by the labor where the labor dispute occurred. and are participating in or are financing or directly interested in the dispute. So there is already existing statute that was put into place to help the Department of Labor make determinations on lockouts. As we've discussed previously, lockouts are covered by current law for unemployment benefits. So those definitions and those interpretations of statute would apply to a labor dispute that was not a result of a lockout, but actually was a result of workers going on strike over economic conditions or an unfair labor practice. I do want to say that, again, I believe that these kinds of disputes would be adjudicated by the Department of Labor. I think there are ample protections in our Department of Labor in their fraud division. They have uncovered fraud, especially during the COVID period. There were many times that we went through this in the Department of Labor. I think they're trained professionals who know how to detect fraud. I don't think we're looking at a situation where an individual would just walk off the job and claim a labor dispute, and I don't think that would be found to be a valid claim through the Department of Labor unemployment unit. So I do think that we are well protected in the state of Connecticut. As to the good senator's question regarding whether it's legitimate to require the employer to pay back, to have their experience rate adjusted during a labor dispute, clearly that is the way our unemployment trust fund is structured, that when there is a layoff, or in this case when there would be a strike, that the experience rating for that employer would be calculated to replenish the funds of the unemployment trust fund, insurance trust fund, to adequately cover those that time where workers were collecting benefits. And you know, obviously we disagree, I'm sure, on whether or not that is valid, but in my opinion it is valid. Through you, Madam President.
Senator Sampson.
Thank you very much, Madam President. I appreciate the lengthy answer, and there's a lot there to get into. And I'm going to revisit the question that I asked in a minute, but since it was brought up, let's talk about lockouts for a second. A lockout is an entirely different scenario. A lockout is a situation where the employer is shutting the door and refusing to allow the employees to work. And they may be doing that as part of some sort of effort to renegotiate the terms between the employer and the employee, but this is a case where the employer is preventing the employee from working. It's the same thing as being fired. It is the exact purpose for which unemployment compensation was created, to give benefits to people that are unemployed through no fault of their own. The point of this entire debate is the fact that we're turning that entire system on its head. To try and use a lockout as a comparative example to someone who's voluntarily walking off the job is not the same thing. You set up a program that says, look, we understand from time to time people are going to end up between work through no fault of their own. The place that they work has to reduce their workforce, or some other change occurs where they're out of a job. Well, we're going to provide a benefit in the form of unemployment insurance. That's a perfectly reasonable concept. It's the one we've been operating under for decades. If an employer locks out an employee, that's a similar situation. They're locking them out. The employee doesn't have income. The unemployment fund exists for them. This is different. This is totally different. This is a situation where the employee or employees is making their own choice. They are voluntarily, of their own free will, ending their opportunity to receive employment. And forgive me, I appreciate the desire for the chairman to continue to explain that her opinion is that this will be easily resolved by the Department of Labor. But I've got nothing to say that in any statute or regulation. We defined a labor dispute as any disagreement between an employer and employee. That's basically it. Right now, labor disputes are very often challenged by employers because they have the reasons that are required for someone to be eligible, that they are not working through no fault of their own, that they are able to work, and that they are looking for work. An employer can dispute those things, but when you take those three things away, as this bill does, and simply say there's a dispute, well, then there's nothing more to argue. There will no longer be disputes at the Department of Labor over unemployment because simply all that has to happen is the employee says, I'm in a labor dispute with my employer. End of discussion. That's it. You're approved. Have a nice day. Unemployment compensation fund bankrupt. Unemployment insurance premiums go up. Businesses leave. This is where we are. This is what this bill is about. This is why we're debating it. This is why, frankly, and thank heavens that the governor is reasonable enough to be talking about vetoing this bill again. Thank heavens that we have some adult in the room realizing that you can't dismantle a system that works for a political benefit and ultimately demolish our economic viability as a state. Thank heavens. I'm going to ask my question again. From a philosophical standpoint, the reason that this policy is before us is because we have a disagreement over whether or not the state has a role to play in interfering with a employer-employee contract agreement, or in this case, a disagreement or labor dispute. I don't think we have one. I think our job, as I mentioned from the outset, is simply to make sure that the parties live up to what they have obligated themselves to in their contractual agreement. That's it. That's the role of government. The court's there to protect those parties when one of them goes afoul of the other. But apparently the majority thinks that it's okay to stick our nose in that contract and decide the terms for the parties. I disagree. But my question is, since you think it's a good idea to stick our nose in, then what is the justification for choosing one side of this agreement? That's what I really want to understand. I want a concrete answer to why the majority thinks it's okay for that to happen. Through you.
Thank you. Senator Kushner.
Thank you, Madam President, and the good gentleman and I have disagreed before. This isn't the first occasion, and I understand he's very passionate in his belief. And some of the statements that he just made I would dispute, but rather than going item by item, let me just point out that in this very paragraph of the bill that is taken from current statute, there is a very definite description of labor dispute. And it is that description that has been used by the Department of Labor in the past to determine when there is a lockout. The same would be true to guide the Department of Labor to determine when there is a strike and when a claim of unemployment for striking workers should be upheld. And I think going to the question that was asked about why I think this is a good idea or why the majority thinks this is a good idea, you know, we have seen this work in other states. It has not caused the demise or the destruction of New York State. And it's been on the books in New York State since the 1970s. Only recently, in 2020, was it improved, and I believe they are actually reducing the waiting period even from 2 weeks to 1 week because it is working in New York State. I think what's important to recognize is that when workers go on strike, they are most generally protecting their jobs, whether it's a dispute over job security or whether it's a dispute over retirement security and having access to the pensions that they may have contributed to for years, or whether it's a dispute over continuation of health care, affordable quality health care. These are the issues that workers make that difficult decision to go out on strike. And when that occurs, it has been in the judgment of other states that are neighboring New York and New Jersey that the community and the state benefits when those workers are provided unemployment, when those workers are able to put food on the table, when they're not thrown out of their apartments or their houses because they can't afford the rent, because they're standing up for something they believe strongly in. And that hasn't caused the demise of New York State. It hasn't caused the destruction of New Jersey. And I believe that what we're doing here, and there are many, many laws on the books that determine the relationship between workers and employers, particularly unionized workers and employers. Many, many, many laws on the books there are decades of case law that has really set the terms. And in many of those cases, it does make it beneficial to the employer. And we've seen that happen over decades. But in this case, this bill isn't about advantaging one side or the other in this dispute. It is ensuring that when workers exercise their legal right to strike, that they have the ability to collect unemployment so they can meet their most basic needs, which again, unemployment is half of your wage typically, and there's a cap on that. So nobody's getting rich on unemployment, but they are able to put food on the table. And that's why I believe this will not cause the destruction of the state of Connecticut. In fact, this will make Connecticut a much more family-friendly a state where the middle-class worker feels protected. And I think that's what's so critical, and why I feel equally passionate about passing this bill in this chamber today. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the gentlelady's remarks and her equal passion to that of my own. I just want to make a clarification in the middle of this debate that I absolutely 100% defend the notion of collective bargaining. That is one of the reasons why I'm opposed to this legislation that is before us. Because effectively what this bill does is it eliminates collective bargaining over this particular situation. This is a conversation that we've had several times in recent years, which is that the Labor Committee in the Connecticut General Assembly, under its current majority rule, consistently makes policy that benefits employees at the expense of employers that would normally be the subject of collective bargaining. In my view, if there is a collective bargaining negotiation and the employees manage to convince the employer that they should be eligible for a benefit if they go on strike, then more power to them, in my view. The point of the collective bargaining concept to begin with is that there's strength in numbers. It's not just one employee, it's a group of employees being able to hold the employer to account as a group, effectively having the power to shut down that operation completely. That's the power that they have. And in fact, throughout history, we watched collective bargaining actually put some businesses out of business because the employees fought too hard for benefits that actually made the business fail. What's happening here is we're actually having the state government, the most powerful entity that we have in our state is the government, and they're going to use the force of government to go ahead and double down on one side of that collective bargaining agreement by putting things into the statute, right into law, prohibiting those parties from negotiating those terms themselves. That is why I am so frustrated all the time. It drives me crazy because of the view that's pervasive in the world that somehow Republicans are anti-union. I'm not anti-union at all. What I'm anti is anti-government interference. I don't like the government coming along in a negotiation between parties that can handle it on their own. They don't need our help. They're out there in the world, they're doing their thing, the business is running a business, the employees are looking out for their interests, they form a union, they collectively bargain, they negotiate terms, everybody's happy. Happy until the state comes along and some politicians want to use political power as a mechanism to engender their favor with whatever group special interest there is. And that's all this is about. That's what's going on here. When everybody knows that the government's got no business sticking their nose in this negotiation. And to try and use the power of a legislature to interfere with a private contract between individual parties, it's wrong. It's morally wrong. It is in direct contravention to the way the country was founded. It's constantly a frustration that I have, that I got to defend myself as someone, oh, you're attacking the union. I'm not attacking anyone. I'm protecting collective bargaining from the government. And that's what I'm doing again today. How far is this policy going to go through you, Madam President? We established that the notion of a labor dispute is a very, very low bar. But if we're going to start to give benefits to people who voluntarily leave employment, what is to stop us from giving it to anyone who just, quits their job because they're unhappy? How is that not a labor dispute? Through you.
Thank you. Senator Kushner.
Thank you, Madam President. And I do want to refer to the bill that is before us here. And if we look at lines starting at the underlying bill before it was amended, it started on line 158. And in that, it very specifically defines a labor dispute with regard to unemployment benefits. As I mentioned, it previously applied and was directed toward understanding workers who were engaged in a labor dispute that was a result of a lockout. But it does very clearly say that the provisions of this subsection do not apply, and that's starting on line 162 of the underlying bill before it was amended. The provisions of this subsection do not apply if it is shown to the satisfaction of the administrator, that would be the administrator in the Department of Labor, that, and if you skip to B, Roman numeral 1, small I, the individual is not participating in or financing or directly interested in the labor dispute that caused the unemployment, and 2, the individual does not belong. So it does not apply if the individual does not belong to a trade, class, or organization of workers, members of which immediately before the commencement of the labor dispute were employed at the premises at which the labor dispute occurred. So in statute already, there is a very clear definition, and we are broadening it to include workers that are involved in a labor dispute, but that still, this subsection would not apply unless that individual belonged to a trade, class, or organization of workers who immediately before the commencement of the labor dispute were employed at the premises. So I believe it's very clear in statute, and it's before us today, that our modification of this part, this bill would change that statute to apply in the same way to workers who are engaged in a labor dispute, which we commonly call a strike. Through you, Madam President.
Thank you. Senator Sampson.
Thank you very much, Madam President. That doesn't change the fact that a labor dispute we've already defined as an extremely low bar, and the definition that was just described, I don't think it makes any difference to the disagreement we're having over the extent at which this applies to single individuals, groups, whether they belong to a union, etc. I don't see how that makes any substantive difference to that. I'm just trying to figure out which way to take this conversation next. Clearly, we have an impasse, and at the end of this discussion, the votes will be cast, and there will be a decision made. And I will be relying on others to do what I have failed to do, probably, which is to stop this bill from passing at least this chamber. But before I end my discussion, let me just touch on a few more topics, just because I'm curious. I've given my opinion on a number of these things already, but I'm curious to hear what the chairman has to say. What is there any concern about the potential insolvency of the unemployment trust fund on behalf of the majority? Or do you just feel like this is such an isolated event that it's not going to make any substantive difference to the number of people collecting unemployment compensation? Is that a fair characterization of the majority's position through you?
Thank you. Senator Kushner.
Thank you, Madam President. Rather than determine whether what the good senator said is a fair characterization, I'd just rather answer the question about whether or not I'm concerned about its impact, this piece of legislation and its impact on the Unemployment Insurance Trust Fund. And I do believe that the impact of this would be no different than the impact of any worker that is laid off, due to the fact that we do have experience rating and that there would be replenishment of the fund based on that experience rating that is built into our trust fund and the structure of our trust fund. Having said that, I want to recognize that there have been very few strikes that have lasted longer than the 14 days that are suggested in this piece of legislation. That there was a study done by the Economic Policy Institute that reported in a look-back period of 4 years that these labor disputes and strikes were very far and few between that extended beyond the 14 days. If you look back to a strike that I think we all are familiar with because it was in every one of our communities here in Connecticut when the Stop and Shop workers went out on strike, it was a pretty big deal. There was a lot of attention paid to it, and a lot was on the line for those workers when they were thinking about whether or not they were going to have family health care any longer, whether they could afford the health care policy under the proposals that were being made. It was one of the big issues of that day. Even that strike was 11 days. It did not go on for the 14 days. There have been several large strikes that we have heard about that were pending that could have occurred. Recently, there was a settlement in the electric boat in the MDA, the Marine Draftsmen's Association. UAW Local 571 settled a contract recently after there was much thinking that there could be a strike. We have heard that there is an agreement with the 1199 workers who were planning a major strike that would have impacted thousands and thousands of workers in our communities. That has been settled. Recently, just as recent as yesterday, there was an agreement reached in the Pratt & Whitney strike, and even though that was a strike of some duration, it was 22 days. So those workers would have only received benefits from the 14th day on. I know that the estimates that we have relied upon look at the cost to the unemployment trust fund at below about 0.04%, 0.04%. And that matches up very closely what we've seen in New York and New Jersey. So in that regard, I believe that we are in a position where we have enough monies in our trust fund to cover the costs should this occur, and that, as I mentioned before, those costs would then be repaid by the employer through the experience rating. Through you, Madam President.
Thank you. Senator Sampson.
Thank you very much, Madam President. I appreciate the gentlelady's comments, although I feel like I'm listening to a bad commercial for financial products. You know, past experience does not guarantee future results, especially when you are changing the rules of the game. Would the gentlelady acknowledge that we're changing the rules of the game here, that there is very likely to be a change in experience going forward? Once you tell people that we're going to provide a benefit of unemployment compensation after a strike extends beyond 14 days, isn't it very likely that there will be more strikes, not less, and that those strikes will go on beyond 14 days? Through you.
Thank you. Senator Kushner.
Thank you, Madam President, and through you, I do caution my good colleague about saying I sound like a bad commercial. I think we've had a very respectful relationship over the last several years that we've worked together, and that comes close to perhaps a dig that was unnecessary. But I do want to say that we do, of course, look at past experience. We base so much of what we do in government, in laws, in creating fairness in our society. Another word I know you object to in every context that I use it in. But we have to look at the experience, not just of our own experience in the state of Connecticut, but this matches the experience in New York and New Jersey. And in fact, in New York and New Jersey, we haven't seen creation of greater number of strikes in those states. And we're talking about over decades in New York. So this is not something that has been untested. We are not approaching something new in Connecticut that is totally untested, because we have the ability to look at those other states and see what the impact has been on not only the unemployment trust funds of those states, but also of the number of strikes and the length and duration of strikes. So I think we are in a good position to determine not only the importance of this piece of legislation, but also what its impact will be on the state of Connecticut. Through you, Mr. President. Good to see you up there.
Thank you, Senator Sampson.
Thank you very much, Mr. President. And it is good to see you up there. I apologize to the good senator if she took offense to my comments. I was merely attempting some humor, and I certainly wasn't trying to put any, a negative message about you personally. I'm just suggesting that the repeated affirmation that we've had very few lengthy strikes in the past is any indicator towards what's going to happen in the future. And we've already established that this particular bill is not the same as the law that exists in New York. It is not the same as the laws that exist in other states or have been even proposed in other states. This is its own set of language. I think it's more broad than all of those other examples. I do believe it extends beyond unions. I do believe it extends beyond strikes, beyond collective bargaining. It actually gets to individual employees walking off the job. But for the sake of this debate, I'll continue to use the examples that we've dealt with. And I think it's quite clear that if you remove the pain from either party in a negotiation, they obviously can persist in a longer holdout to reach their ultimate goals. And that would be true whether you gave a benefit to the employer or the employee. If you told the employer, hey, the government's here, and don't worry, if your employees go on strike, we're going to continue to subsidize your business as long as necessary until the employees come back to the table, then the employer would gladly let their employees go on strike regularly, wouldn't they? And that's exactly what this bill does in the reverse. Exactly what this bill does in the reverse. It tells the employees, we're going to continue to pay you even if you do not go back to work. Even though that unemployment was set up for people that are out of work through no fault of their own, who are able and looking for work, no matter, we're going to include you also, and we're going to give you the ability to take from that pot to sustain you. Well, clearly that's going to allow those folks that are going on strike to persist a lot longer. The good chairman mentioned that the Pratt & Whitney strike ended after 22 days. I'm going to tell you right here, right now, if this law existed, it wouldn't have ended after 22 days. They would have stuck it out longer because they could have. And that's what this bill is about. This bill very clearly is designed. Why are all the labor unions clamoring for this bill? Why did we have so much testimony by labor unions if it's not going to make a difference? Of course it's going to make a difference. It's a ridiculous argument to say it's not going to make a difference. The fact is they want it because it puts a benefit on their side of negotiations. It's going to allow them, and again, I'm not suggesting that they really want to collect the unemployment. That's not the goal. That's just a tool to make sure that they put the employer in a much more difficult position so that they can get a better agreement at the end of the day. Everybody knows it. It's not a mystery. I don't understand why when we have these debates, that seems to get clouded in the discussion to suggest that somehow, nothing's going to change. Our workers' compensation, or our unemployment insurance experience is not going to. Of course it's going to change. Of course it's going to change. We're changing the rules of the game for the purpose of making it change. I think I'm just going to wrap up, Mr. President, by suggesting that, we've covered this subject ad nauseum now several times over the last several years. And I'll just restate very briefly my concerns, which is, number one, interferes with the private negotiation between an employer and an employee. What I view as something that the government does not have a role to play in at all. And that includes a collective bargaining negotiation where the parties are more than equipped to be able to manage the negotiation and the terms that they result with on their own. And that it is in fact a violation of our value system as Americans to use the force of government to interfere, to create a benefit or an adverse situation for either party in a free negotiation for free citizens. Part of the concept of being American is the idea that we treat people with the same opportunity, with the same laws. Laws should apply to everyone equally. And that's not what's happening here. What's happening here is the government's taking an active role in benefiting one side of a negotiation. And that's wrong. And the direct result of this is going to have economic impact, negative economic impact in the state of Connecticut. If I'm a business and I'm looking for a new location and I'm trying to decide between states I want to place my facility at, I'm going to look at Connecticut a little differently if this becomes law. That's obvious. No one should need me to explain it to them. Clearly, businesses are going to be less desirous of moving to our state. And our existing businesses, the ones that are struggling in our state right now because of the lack of affordability of everything, our high energy rates, which I'll remind everyone in the circle once again that here it is, we are about a week from the finish and we still have not addressed the public benefits charge and the electric rates issue, which we should be doing, but instead we're talking about a bill that is very likely only being discussed for political theater because it's likely to be never brought up in the House and probably vetoed by the governor if it were. But this is what we're doing. We're debating this bill rather than solving the problems that the people of Connecticut basically hired us to handle. I'm ready to get to work doing those things immediately. This bill is going to have a negative impact on the state of Connecticut. There is no question about it. How much that impact is remains to be seen. And frankly, I don't want to find out. So I'll be a no today. Thank you, Mr. President.